And as I introduce Rob, I want to also thank the co-sponsors of this event, the Department of History, the African American Studies and Research Program, the Asian American Studies Program, Center for Democracy and a Multiracial Society, the Native American House, and the College of Law. When you have the bright idea of bringing someone to campus, there's a sort of begging process that goes on where you get the idea and you get some money and you go around begging other people to help make this thing happen. So we're grateful to all those programs for helping. The year our speaker today was born, Justice Stanley Reed of the United States Supreme Court wrote a majority opinion that threw in a case that threw out an Alaska tribe's suit for compensation for land that had been seized by the United States and incorporated into a national forest. Justice Reed asserted that the Indians, this group who had never agreed to surrender the territory in question, had no claim to the land that the national government, no claim to the land, and that the national government owed them nothing in compensation. Reed wrote, in a famous phrase, "Every American schoolboy knows that the savage tribes of this continent were deprived of their ancestral ranges by force, and that even when the Indians ceded millions of acres by treaty in return for blankets, food, and trinkets, it was not a sale, but the conqueror's will that deprived them of their land." We live today in a very different world. Sophisticated tribal governments operate throughout the United States, managing tribal resources, social services, education programs, hospitals, and business enterprises that range from casinos to farms, ranches, to the Seminole tribe's latest acquisition, the Hard Rock Cafe chain. Robert Williams has helped bring this new world into being, and in the process has helped students, lawyers, judges, and other public officials to replace Stanley Reed's stereotypical schoolboy version of history with an appreciation for the reality of tribal sovereignty. That sovereignty is a theme of Native American history, and it is evident in contemporary Indian communities. It derives from the ancient presence of indigenous peoples in this continent and their unfailing belief in the integrity of their traditions, the wisdom of their elders, and the unbroken thread that links them both to the past and to the future. In his career, Robert Williams has drawn both from his own Lumbee tribal heritage and from educational institutions. He's a graduate of Loyola College in Baltimore and Harvard Law School. He has taught at the law schools of Rutgers, Harvard, the universities of Wisconsin and Washington, and for the past 20 years at the University of Arizona, where he is E. Thomas Sullivan Professor. Like many non-lawyers, I first encountered Robert Williams in print. His first book, The American Indian and Western Legal Thought, published in 1990, set the rhetoric of American Indian law in the broad context of European writings about the conquest of infidels, a tradition that began with the Crusades and which sadly continues into our own time. Linking Arms Together, a book about treaty making and diplomacy in colonial North America, opened yet another unexplored arena, a world in which Europeans and Native peoples lived as political equals who managed to coexist on this continent by seeking common ground. His most recent monograph, Like a Loaded Weapon, The Rehnquist Court, Indian Rights, and the Legal History of Racism in America, is a searing and courageous critique of the predicament of modern tribes, entities who are both the beneficiaries of and the victims of contemporary jurisprudence. At the same time he's been producing these provocative and insightful books, Williams has been an active advocate, contributing to appeals court briefs, serving as legal counsel to tribes, and consulting internationally on indigenous issues. He's also one of the authors of the leading case book in American Indian law, a text now in its 5th edition. Robert Williams has helped us look back to Justice Reed, as well as forward to a new world of tribal sovereignty, cross-cultural learning, and justice. We are grateful to have him with us today.
So is my mic on? Yes. Well, thank you, Fred, and thank you to the Miller Committee and to the university for inviting me here today and getting me to leave Arizona in March to come to Illinois. But it's beautiful, and I'm sure it was all arranged, so thank you. It's really a pleasure to be here. And I'm also excited to talk about the work that we do at the program which I direct at the University of Arizona, the Indigenous Peoples Law and Policy Program. And the question that I want to address, Fred and I sort of talked about this lecture, and we sort of went back and forth, and we came up with this idea of titling this lecture, Whether the Law Can Protect the Rights of Indigenous Peoples. And most of the work that we do in our law clinic and in our representation, we ask that question all the time. And I think by the time that we're done this talk today, the answer will be, it all depends on what law you're talking about. I'm going to talk about domestic law, and I'm going to talk about international law, and I may even talk also about tribal customary law. That one of the fascinating things about doing Indian law is that you really are dealing with so many different legal systems, legal philosophies, and legal theories, and there are many constituencies that you have to address in this type of work. Fred talked about my book, The American Indian in Western Legal Thought, where I was trying to answer the question that when Europeans come here to the New World, where do they get this idea that they can just claim it as their own? So you can see the Columbus voyages, you can see Henry Cabot, Henry Hudson, Jacques Cartier. What's interesting about what's called this period of European discovery is that uniformly, when Europeans travel to what they called the New World, they would take possession of territories that were already occupied by the indigenous tribal peoples that they encountered. And as a law student, I always wondered what was the mentality that made Christopher Columbus think, as he gets off the boat and encounters those Indians in the Bahamas, that he could claim all the land that he could see for the King and Queen of Spain. Or what was it that convinced Henry Cabot, when he sailed with a charter from King Henry VII to go and discover lands not possessed by Christian kings or people, that he could claim all of the land from the shore for as far as the eye could see for the English crown? And what you find is that Europe, between the 15th and 16th century, is operating at a very early period in the history of what's called the law of nations, of international law. It's interesting if you start matching up the historical periods, that the discovery period coincides with the European Renaissance, and you're beginning to see movements toward gradual secularization of European society. And you actually have a number of different competing legal systems. You have papal law, you have domestic law. You also have this idea of a law of nations, that when Europeans in the 1500s and 1600s talked about the law of nations, they were talking about an idea of natural law. We all know about Thomas Aquinas and this tradition of natural law as somehow being, what people ought to do, and in fact, what people do. And the idea of the European law of nations develops that the law of nations, international law, is whatever civilized nations do, whatever Europeans do. And uniformly, Europeans would sail to the Americas, and wherever they encountered lands occupied by heathens, infidels, or savages. Those were the three legal categories. They are actually well-defined legal categories. Heathens, infidels would be the Saracen Turks, the Muslims. Savages would be people who were idolaters and had absolutely no gods that they worshiped that Europeans would understand. Wherever Europeans encountered these heathens, infidels, and savages, they could claim those lands for the Christian European prince that they sailed under. So the thing I want us to focus on is what's being claimed, the property. It's the property right that is being claimed. And one of the consistent themes of this lecture will be to keep your eye on the ball. I'm a lawyer, I'm a litigator, I always try and make sure my juries are focusing on what I want them to focus on. And I want you to focus on this idea of property, this idea that Europeans come to the New World and don't have any sense of obligation to respect indigenous people's property rights. Why is that? Well, if you trace back the history, you find out that Europeans actually had about a 500-year head start on this practice of claiming property that belonged to infidels, heathens, or savages. It actually begins with the medieval popes. So here's Italy, and these are the Crusades. And beginning around the late 1090s, the Turks, Muslims, began to invade and reassert primacy in this area called the Levant, the Middle East. And were starting to threaten Constantinople. And so the Eastern Christianity, the Catholic Church in Constantinople, requested the Pope in Rome for help. And the Pope in Rome issued a call to crusade. And these are some of the first crusades that you see. And the idea of the crusades was that the Pope could commission Christian kings and princes to launch military expeditions to seize lands that had been unlawfully seized from Christians. Now you get this idea of, well, how could you fit the Crusades into this idea that the Pope had the authority to order Christian armies to reclaim lands seized from Christendom? Well, this was part of the Holy Roman Empire. This land had originally been claimed by Rome, and in fact, when Constantine moves out of Rome and hands over the western part of the empire to the papacy, he was alleged to have made what was called the Constantinian donation. And the Constantinian donation was this idea that the papacy in the stead of the emperor basically held second title to the property of the empire. And so the Crusades are originally justified on this idea that Islam had unlawfully seized Jerusalem and the Holy Lands. And so one of the basic arguments for St. Augustine's just war was the recovery of stolen property. So that in the 1090s through the 1100s, the Crusades are originally justified on this idea that these folks had unlawfully stolen property from Christianity, and therefore the Pope could issue crusading banners and have armies attack them and seize that property back. Well, the Crusades actually became pretty successful. And what was happening was that more and more Christian princes who were establishing trading posts and military posts in this area wanted to extend their ventures beyond areas that were under the traditional jurisdiction and ownership of Rome. And so in 1243, Pope Innocent IV, who was a canon lawyer. In fact, the evidence suggests that Pope Innocent IV had been a professor of theology at the University of Paris and that his star pupil had been Thomas Aquinas. So it's probably there's very good historical evidence that much of what Aquinas learned about natural law comes from Pope Innocent, Sinobaldus Fiescus. Henry Maitland, the great English historian, called him the greatest legal scholar ever to sit upon the papacy. And so he's asked to address this question of whether it is licit to invade a land that infidels possess or which belongs to them. So you can see what we do in law school is kind of distinguish the question. This is a different question from whether the Pope could authorize Christian princes to come in and seize back lands that have been unlawfully taken. This is the next step. And you see what his answer is. The Pope has jurisdiction over all men and power over them in law, because Peter had said, "Thou art Peter, and upon this rock I'll build my church." It's called the patrinological foundations of the papacy. And by the 11th century, a theory had developed that the papacy had universal jurisdiction in de jure, if not de facto, okay, at law, if not in fact, because all people are intended to be brought into the universal Christian commonwealth. And so you can see how this reasoning of the Pope is extending from this set of assumptions, so that through this power which the Pope possesses, I believe, if a Gentile who has no law except the law of nature to guide him does something contrary to the law of nature, the Pope can lawfully punish him. If infidels prohibit preachers from preaching here, they sin and ought to be punished. And so if infidels do not obey, they can be compelled by the secular arm, and war may be declared against them by the Pope. So there you have a rather significant expansion of the theory of crusades against infidels, heathens, and savages, where they violate natural law, where they refuse to allow preachers to come into their midst. It's okay for the papacy to issue a crusade against them. Now, what's interesting is you might want to take a look at these maps. I'm going to include them along with the lecture. And you can see the original crusades are moving overland. So the first crusade, you're marching an army overland. That's tough. But what happened was, as Europe becomes more involved in the crusades, they begin to adopt some of the more modern technology, sailing technology of the Arabs. And so particularly the Italian families, the de Medicis, the Genoans, the Venetians, begin to develop very sophisticated merchant marines. And so instead of marching your armies here, the European monarchs who wanted to launch a crusade to the Holy Land figured it was easier to march your folks down to Italy and then make a contract with these large Italian families to ship your troops. And then, of course, we all know, where's Richard the Lionhearted while Robin Hood's having all that trouble, okay? He's off on crusade. He has to get back. So who do these Christian monarchs leave the administration of their trading colonies to? These large Italian families. Did you ever wonder why all the original discoverers of the New World were Cabato and Columbus? They were Italians because in 1450s, the Seljuk Turks reorganize themselves and basically push all the Christians out of the Middle East. Now, where are they going to go? Well, they take their capital and they take their ships and they go to the Iberian Peninsula. And the reason they do that is because the Portuguese, Prince Henry the Navigator, has been sailing along the coast of Africa and is told as he sails along the coast of Africa that if you keep on going, you'll eventually get to the other side. And so these, the philosopher Zoroaster said that people who live in this part of the world, the Middle East, will always be condemned to live in interesting times, right? It's the crossroads of the world. This is where the silver is. This is where the silk is. This is where the spices are coming. Whoever controls the trade here controls the goods of the world. And so the Europeans are looking to get here again to India, to Japan, Sipanago, as Columbus called it. And so you have this first wave of colonization of the African coast. And in 1450, the Pope issues a papal bull, a legal edict, which grants all of Africa to Portugal. And if you read the papal bull Romanus Pontifex, it says that the Portuguese report that the people who live in Africa are infidels, heathens, and savages. And so the papacy extends the theory of the Crusades to cover these folks, because they won't admit preachers, they run away, they are idolaters, they practice sexual perversion, they violate natural law. And so the papacy takes these people into guardianship and grants their territory to the King of Portugal, who undertakes an obligation to Christianize these folks. Well, that's great for Portugal. What about for Spain? Well, it just so happens that one of the early Italian navigators who was given a grant by the King of Portugal to the Madeira Islands was Perestrello. And Perestrello was the father-in-law of one Christopher Columbus, who told his son-in-law, hey, all the good trading posts are taken up. All the early grants have been made from 1450 to 1490. What do you need to do to take care of my daughter? Go west, young man. Sail to the west. Don't go around here, it takes too long. I think there's a shorter sea route to India and to Sipanago, Japan, right here. And we all know the story. Columbus is empowered by Ferdinand and Isabella after a special priestly junta decides for 4 years on whether or not a voyage by Spain to the west would violate the papal bull Romanus Pontifex. And that papal bull had the threat of excommunication for anybody who interfered with Portugal's rights. Once they decide that no, this territory out here to the west, whatever might be, is open sea, it's not covered by that bull, Columbus is financed with a voyage. He comes back to Spain and he reports what he's discovered. And the Spanish crown that's just appointed Pope Alexander, who's a member of the Borgia family, who happens to be Spanish, basically gives Pope Alexander the documents for a papal bull by which the entire New World of Columbus, discovered by Columbus, is granted to Spain. And in order that you may enter upon an undertaking so great with greater readiness and hardiness, endowed with our apostolic favor, we, by the authority of Almighty God, conferred upon us by Blessed Peter. Remember, I talked about the patrinological foundations of the papacy. Where did the Pope get his jurisdiction to go granting territories and peoples? From St. Peter. And the vicarship of Christ. So notice the legal language that this document is infused with. This is a grant of territories. This is the exact type of grant that kings and queens of Europe used to pass properties around all the time, which we hold on earth. Give, grant, assign. Anybody ever look at their deed for their house? Hereby give, grant, assign, deed, all the language is in there to make this as unambiguous as possible. kings of Castile forever, with all the dominions, cities, camps, places, all rights, jurisdictions, and appearances, all islands and mainlands found and to be found, discovered and to be discovered, with this proviso, that none of the islands found and to be found, discovered and be discovered, beyond the line of papal demarcation toward the west and south, be in the actual possession of any Christian king or prince. And by that grant, Spain is given the entire New World, except the Pope drew a line of demarcation. Went right about there, just about where Brazil is. Guess who got Brazil? Portugal. What language do they speak in Brazil? It's all the Pope's fault they can't talk to each other. A little bit. Of course, then comes the Reformation, and the English crown says, hey, I'm the Pope. I'm going to set up, King Henry VIII says, I'm going to set up a church. It's going to be the Church of England. I'm going to be the King of England. I got an even better deal. I am going to be the Pope of my own church. Now, Henry had a lot of issues. He really couldn't follow up on Cabot's discoveries. Remember Cabot's discoveries in 1497? They were chartered by Henry VII. In fact, after Cabot comes back and reports on his discoveries, Henry VII is worried that they may interfere with Portugal and Spain's rights under those papal bulls. And since Henry VII is a Catholic king and is fighting the War of the Roses, and the last thing he needs is a rebellion and get excommunicated, says, we're not going to go there. So literally, England sleeps on its rights of discovery from Cabot for over a century. And then finally in 1606, following some initial exploratory colonies set out by Raleigh and attempts by Humphrey Gilbert under Queen Elizabeth's reign, Henry's daughter, King James comes to the throne, and by this time you've had the Armada. It's absolutely clear that Spain is at war perpetually with England. And so London merchants and Bristol merchants convince the king that he ought to issue a charter allowing for the colonization of land in the New World claimed and discovered by Henry Cabot for the benefit of England. And so in 1606, the first charter of Virginia is issued. And again, look at the language. We, greatly commending and graciously accepting of their desires for the furtherance of so noble a work, which may by the providence of Almighty God tend to the glory of his divine majesty in propagating Christian religion to such people as yet live in darkness and miserable ignorance of the true knowledge and worship of God, and may in time bring the infidels and savages using the same legal categories. This is the same form of legal discourse. This is what the European law of nations is. That an English king, after the Reformation, that a European prince has the same power that the Pope had. Wherever you can find infidels and savages living in those parts to human civility, you may claim their land. They have no property rights that Europeans need to recognize. Now, it's interesting when you compare the development of the law of nations in Europe between European states themselves. In 1648, the Europeans get together and decide to end their centuries of wars of religion and sign what's regarded as the first sort of step in the modern European state system, the Peace of Westphalia. 1648, and if you look at the map of Europe, you can see that this peace really helped stabilize what we now know today as modern European boundaries. And if you look at this treaty, the Peace of Westphalia, and look at what the individual European states agreed to between themselves, you see a complete asymmetry in the way that Europeans were dealing with Indian tribes, indigenous nations, and dealing with themselves. Between European nations, there was recognized sovereignty in nation states and the fundamental right of political self-determination. The doctrine of discovery totally denies that for indigenous peoples. Legal equality between nation states. Under the doctrine of discovery, Indians could be enslaved. None of their property rights had to be recognized. Internationally binding treaties between states. Europeans uniformly regarded the treaties that they signed with tribes as documents of convenience and expediency and could be broken without any moral compunction or without any consequences under concepts of international law. And then finally, whose rule? His religion. Essentially, the peace outlaws wars based upon religion. If your king is Catholic, you're Catholic, and that doesn't provide an excuse for war. Whereas what we've seen for indigenous peoples is that religion was one of the primary bases for invasion. So it's this asymmetry within the European law of nations, which treats indigenous peoples one way and other Europeans the other, that becomes the source of this idea of the property rights of indigenous peoples. In fact, you can see the European colonial empires that are built upon this asymmetrical system, that all of these European countries, Spain, the English, France, base their colonial claims on their rights of discovery in the New World. So that in 1823, when Chief Justice John Marshall finally gets a case before the Supreme Court on whether this European law of nations would apply within the United States in the case of Johnson v. McIntosh. Johnson was the representative, the last in the long line of land syndicators who had bought land directly from the Indian tribes in 1773 before the Revolutionary War. There was a lot of chaos on the frontiers right here in Illinois, in fact. The purchase here was involved with the Illinois and Piankashaw Indians. Johnson, his syndicate, bought the land directly from the tribes with no permission from the king. McIntosh was a Revolutionary War era veteran, I think was actually part native, but had been entitled to land by virtue of having served in the Revolution, and acquired his title from the United States government, which had acquired the territory from the Indians at the Treaty of Grenville. So Johnson purchases his land first, and then the U.S. government comes along and sells the same land later. And we all know in property law, it's first in time, first in right. Unless, of course, you have no property to sell. And under the doctrine of discovery and the European law of nations, indigenous peoples didn't have any property rights. The only entity that could deal with them and make treaties to surrender their interests was the sovereign, only the King of England, only the King of Spain. Individuals had no right to acquire property from Indians because they had no property that could be recognized. And so Marshall goes through a very nice history lesson to explain how the United States has come to accept this doctrine that goes back to the Crusades. On the discovery of this immense continent, the great nations of Europe wanted to get as much of it as they could acquire. Its vast extent offered an ample field to the ambition and enterprise of all. In other words, there was a lot of land here. And the character and religion of its inhabitants afforded an apology for considering them as a people over whom the superior genius of Europe might claim an ascendancy. So here we have Marshall in his characteristic brilliance kind of summing up almost 1,000 years of European practice. Wherever you met uncivilized people, you could make this deal with them. The potentates of the old world found no difficulty in convincing themselves they made ample compensation to the inhabitants of the new by bestowing on them, the Indians, civilization and Christianity in exchange for the Europeans' unlimited independence. What a deal. And that becomes the legal architecture of Indian land rights in the United States. They don't exist except at the whim of the sovereign. Only the United States government has the authority to recognize or not recognize Indian property rights. As they are all in pursuit of the same object, it was necessary to avoid conflicting settlements and war to establish a principle. So here we go again, Marshall the lawyer, re-summarizing. This principle was discovery gives title to the government by whose subjects it was made. Going on in Johnson, well, what happens to Indians? Okay, what exactly happens to Indians? And what he says is that when you exclude all other Europeans, it essentially drops Indians out of international law. Indians, in other words, are subjects of international law up to the point of discovery. They're subjects in the sense that if you find lands occupied by Indians, you can acquire those lands. But once you discover them, what happens? Those relations which exist between the discoverer and the natives were to be regulated by themselves. The rights thus acquired being exclusive, no other power could interpose between them. In other words, Indians became issues solely of domestic concern. They dropped out of international law. They were no longer governed by the law of nations. The discovering nation could do whatever it wanted. And Marshall is very honest about where this law came from. Why was it that you didn't adopt the normal European law of nations rules, that when England invades France and conquers France, after compensation is paid for the cost of the war, French subjects are allowed to keep their property right? When England conquers France in the French and Indian War, the Quebecois are allowed to keep their property. That's the normal law. Why didn't that rule apply to Indians? Well, because the tribes inhabiting this country were savages, whose occupation was war and whose subsistence was drawn from the forest. Here's that legal category again. To leave them in possession of their country was to leave it a wilderness. To govern them as distinct people was impossible. They could not be assimilated. So a further justification for denial of indigenous rights. Now, not only the United States, but every English-speaking country and every Latin American country adopted the principle of the doctrine of discovery. So that as late as 1930, 1929, Canada, supposedly a civil society, right? Real friendly, everybody loves each other, it's the multiculti bunch. In 1929, in the leading case of Silly Boy, the Canadian Supreme Court, citing Johnson v. Marshall, says the Indians were never regarded as an independent power. Civilized nation discovering a country of uncivilized people or savages held such country as its own until such time as by treaty it was transferred to some other civilized nation. This is what I like. Nova Scotia had passed to Great Britain, not by gift or purchase or even by conquest of the Indians, but by treaty with France, which had acquired it by priority of discovery and ancient possession, and the Indians passed with it. They were just part of the real estate. It's all focused on the property right. That was the problem. The Indians wouldn't go away. That's all that the law of nations was concerned about, was how title to this property right was acquired. You see this same principle reflected in the high point of the Victorian imperial era in Africa. In the 1880s, with the invention of the railroad, European colonial powers were worried about the scramble for Africa and the resources and wealth. So they call a conference in Berlin called the Berlin Conference to sign a treaty to basically divide up their spheres of influence in Africa so as to avoid war with each other. And these spheres of influence were based on the principle of discovery and occupation and the idea that the indigenous peoples here needed European protection. The signatory powers exercising sovereign rights or authority in Africa will continue to watch over the preservation of the native populations and supervise the improvement of the conditions of their moral and material well-being. They did it for their own good. This was the mentality. This was how people, I always ask myself, how can you get to this point where you think colonizing a people is actually good for them? And you can see this buildup of 1,000 years of legal practice and legal ideology, which treats all non-European, non-Christian peoples as savages incapable of owning property or taking care of their own affairs. Even through the League of Nations era, colonial rule in Africa still continued under this regime. The only difference was that the powers that had lost World War I, their colonies were placed under mandate status and administered by the victors to move them towards civilization. Then something happens. I'm moving to the 20th century now, okay? That was all run up. World War II, the Holocaust, the creation of the United Nations, the recognition that singling out a people because of their culture or their ethnicity for discriminatory treatment was not a good thing. And this idea that the way that a nation state treated its own citizens was purely a matter of domestic law was not going to pass muster. That the United Nations and the international human rights system had the obligation to look over the shoulder of nation states to see how they were treating their own subjects. And one of the primary purposes of the setting up of the United Nations was to facilitate the decolonization of Africa and Asia. England and France were destroyed. They needed the Marshall Plan to rebuild them. They wanted out of the colonization business, and they wanted out really bad. And they set up the United Nations to help them get out of colonization. Under the United Nations Charter, there was a decolonization process, which was an orderly process by which England and France and other European countries could shed themselves of these colonial burdens. And during the course of this debate on the UN and decolonization, the issue came up, well, who gets decolonized? What about indigenous peoples, colonized peoples in South America? What about indigenous colonized people in North America? What about indigenous colonized people in the Soviet Union, in China? What about peoples in Australia and New Zealand? And the Europeans are, oh, no, 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 no. No, we're not ready to go there. Okay? We only want decolonization to be focused here. Well, the indigenous peoples and their advocates are saying, how can you justify that? And thank God for the Belgians. The Belgians came up and they needed to get out real bad. Okay? And they just were looking for a way out of this. And the Belgians came up with what was called the Blue Water Thesis. Okay? This is international law. Any colony separated from by blue water, an ocean, is eligible for decolonization. Any colonized people who don't have blue water are stuck. And that was it. That was the compromise that was adopted. That the UN decolonization process would only apply to overseas territories, not to the indigenous peoples whose property was seized by what we call Western settler states. And so in 1955, I was glad to hear Fred do that. He didn't know I had a slide, but I actually have the slide. And the issue was whether or not the indigenous peoples of Alaska, who never had their property rights recognized. Congress had never signed a treaty. Congress had never extinguished their property rights. But Congress and the United States claimed Alaska by virtue of acceding to and purchasing Russia from the Tsar. And Russia had claimed Alaska by virtue of the doctrine of discovery. And so the issue was that when the United States did a test case involving cutting down a few strands of timber, but this was 1955 and everybody knew that Alaska was resource rich. And the only thing that was holding it up was whether or not the natives had any potential claims. So you have to understand the enormity of Tehitan. It was basically the question of whether the indigenous peoples of Alaska had any right to be compensated for the taking of their property. And as Fred read, the court said no. Because why? Every American schoolboy knows that the savage tribes of this continent were deprived of their ranges by force. And that even when the Indians ceded millions of acres by treaty in return for blankets, food, and trinkets, it was not a sale but the conqueror's will that deprived them of their land. 1955, and I'm so glad you said the year I was born, because what I like to tell my students is, in 1955, the year I was born, this is what the Supreme Court did. So don't tell me this stuff doesn't happen in my lifetime. This law that traces back to the medieval Crusades still has enough force to dispossess indigenous peoples of their property right. So can the law protect indigenous peoples? Not U.S. law. It can in certain instances, but the structure I told you, Tehitan, is still good law. Indigenous peoples are subject to the plenary power of Congress. Their treaty rights can be abrogated, and Congress doesn't have to give them due process in doing so. Their reservations could be terminated. In the 1950s, Congress adopted a policy of terminating Indian tribes. And you think about it, who else was the U.S. terminating in the 1950s? Well, dictators, okay? That was the mentality. Indians were in the way. And because all of these European settler states have adopted the doctrine of discovery, which holds that indigenous peoples have no property rights that European-derived governments have to recognize, we see the situation today. Okay, the dots, the red dots, are where indigenous peoples are. The crossed areas are large-scale energy development projects. If indigenous peoples don't have property rights to all these large-scale energy development projects, you can see why this question of whether the law can protect indigenous people's rights is so pressing. Domestic law can't do it. Where do you go to? In the program that I direct, we've been involved for the last 20 years in a number of cases in the international human rights system. Why international human rights? It's interesting. When the folks that drew up the United Nations Charter started dealing with some fundamental issues, we've already seen what they did with the Blue Water Thesis. They basically never thought that indigenous peoples were part of the deal. They did not think that indigenous peoples were included within the types of rights and protections guaranteed to nation states. So if you read the Charter of the United Nations, it's committed to the principle of equal rights and self-determination of peoples and to promote respect for human rights and fundamental freedoms. And you have the Universal Declaration of Rights, which declares an array of human rights principles based on affirmation of the fundamental dignity and equality of human beings. But from about the 1950s up until the 1970s, it was always assumed that indigenous peoples' rights were treated as minority rights. That Article 1 applied to states, that a peoples was a nation state as traditionally understood by international law. So when they say all peoples have the right of self-determination and they can freely determine their political status and freely pursue their social and economic and cultural development, they obviously didn't intend that to apply to indigenous peoples, because that would have led to the disintegration of nation states. So the mentality was clearly nation states have this right of self-determination. Indigenous peoples are ethnic, religious, and linguistic minorities. And they shall not be denied the right in community with other members to enjoy their own culture, profess and practice their own religion, or to use their own language. That's where you guys go. That's where you indigenous peoples go in the international legal system. You go to Article 27 and you seek rights to protection under this minority rights provision. And that's what they were told consistently, over and over again. You don't have the right to self-determination. You have whatever property rights your state guarantees to you, so long as they're not discriminating against you on the basis of your ethnicity. And so what happened was indigenous peoples took that idea and began to develop this notion of minority rights as it applied to them. In the 1950s, the first organization to deal with indigenous rights was the ILO, the International Labor Organization, passed a convention called Convention Number 107, which said that the obligation of nation states that sign the ILO is to assimilate their indigenous populations. That was the legal mandate, to assimilate it. And indigenous peoples began to go to Geneva to the ILO and say, that's wrong. In the 1970s and 80s, what they were saying was, if you assimilate us, you destroy our culture. Remember what I said? Article 27. We all have the right to culture. And so what indigenous peoples realized was that they had to work with the limited legal materials they had to make this argument to the international community that that's right, we'll deal with the international community on Article 27 and minority rights, but we want you to understand our special, unique status. That as a minority, we cannot exist unless you recognize our distinctive culture, which is land-based. And so what you find from the 1970s and 80s is indigenous peoples continuously lobbying international organizations making this point, that you may want to say that we're minorities, but what you have to recognize is that we are a unique type of minority tied to the land, and if we have a right to our culture and to practice that culture, then you have to guarantee us a land base. And so you see indigenous peoples starting to press the UN for a draft declaration on the rights of indigenous peoples, pressing the OAS, including provisions in other international instruments. And you know what happens? They start to get it. Various international bodies start to see the connection. I get it. With regard to the exercise of cultural rights protected under Article 27, this is the UN Human Rights Committee, which has adjudicatory responsibility for enforcement of the UN covenants. The committee observes that culture manifests itself in many forms, including a particular way of life associated with the use of land resources. Especially in the case of indigenous peoples, that right may include such traditional activities as fishing or hunting and the right to live in reserves protected by law. Amazing. The things which had indigenous peoples denominated as savages, hunting and fishing, is now recognized in contemporary international human rights discourse as the thing which perpetuates their culture. And you guys said in the charter that you can't destroy a culture. So that means you have to protect our culture, which means you have to protect our land rights, which means you have to protect our hunting and fishing, which means that you have to recognize that our savage ways are entitled to international human rights protection. Oh no! Oh, how did we get here? You lawyers, you've really screwed things up. The UN Committee on the Elimination of Racial Discrimination. We all know how the West thinks about racial discrimination, okay? It's guys riding around in white hoods, okay? And if it don't look like the Ku Klux Klan, it's not racial discrimination. How is the doctrine of discovery racial discrimination? The UN CERD Committee never even thought about opening up its procedures to indigenous peoples. But what happened was that as more and more international bodies began to grab on to this argument, that the unique cultural heritage of indigenous peoples requires protection of their land rights, they started getting it too. In many regions of the world, indigenous peoples have been or are still being discriminated against and deprived of their human rights and fundamental freedoms. So this sounds like any UN CERD report that you're going to see. It could be a report about Kurds in Iraq or African Americans in the US. It's got all that sort of individualized, civil rights discourse in it. But then look, they've lost their land and resources, the colonists, commercial companies, and state enterprises. The preservation of their culture and their historical identity has been and is still jeopardized. And so the committee calls in particular on states to recognize and protect the rights of indigenous peoples to own, develop, control, and use their communal lands, territories, and resources, never recognized under the doctrine of discovery, where they have been deprived of their lands and territories traditionally owned or otherwise inhabited or used without their free and informed consent, to take steps to return those lands and territories. Reparations, restoration. And so now, after 20 years of work in Geneva, the United Nations is on the verge of adopting a universal declaration on the rights of indigenous peoples. See, what indigenous peoples were telling these international organizations was, all your covenants and all your declarations don't work for us. We need our own declaration. We need these international bodies to set standards that are specifically directed to the unique human rights situations of indigenous peoples. And so passed by the Human Rights Council on June 29, 2006, scheduled hopefully for adoption by the General Assembly before the close of this session in September, Article 26. Indigenous peoples have the right to the lands, territories, and resources which they have traditionally owned, occupied, or otherwise used or occupied, regardless of the doctrine of discovery. They have the right to own, use, develop, and control the lands and resources they possess by reason of traditional ownership. And here's the move that again, follow me closely here. You got a piece of land that the state has granted in fee simple to a railroad company or to a large logging company. They are said to have fee simple title. Okay. But it's a large piece of land and nobody's out there watching the indigenous peoples who for the last 100 years have continued to hunt and fish on that land and apply their customary law. This is my trap line. That's my clan's hunting area. This is where my people always fish at. That's our law. And what international law is recognizing is that as long as indigenous peoples have maintained that connection to their land, have enforced their customary law, it doesn't matter what the white fellow's law did. This will blow your mind. In other words, you could have one piece of property and two separate legal realities placed atop of it. The white world's legal title and the indigenous people's customary law. And what international law says is you cannot extinguish indigenous peoples in favor of the other. And if you do extinguish, if you do decide that they're incompatible, Article 28, you have the right to redress by means that include restitution, or when not possible, just fair and equitable compensation for the lands, territories, and resources which they have traditionally owned or otherwise occupied or used. Now, what happens is that you begin to create a climate. So what bite does this stuff have? Why would states listen to it? What happens is you begin to develop a climate, a number of precedents, a number of arguments, a mindset which says, don't ever cite the doctrine of discovery again. Every international body of the last 20 years that has been confronted by an indigenous rights case where the state has said doctrine of discovery, the international body has said that's not compatible with international law. You need a better reason if you're going to take their lands other than the fact that you claimed it by the doctrine of discovery. And if you take their lands, you have an international obligation to provide compensation. And if you don't, then that group's going to take this type of stuff to the World Bank, to the European Union, to your lenders, to Texaco, to Enron, none of whom want to be accused of violating well-recognized standards of international human rights. That's the way the game works. Most of our work has been in the inter-American human rights system. Why? Because it's close. It actually is a system that the U.S. pays a lot more attention to than the UN, believe it or not, because it's been the system that they invade everybody they don't like. They go to the OAS when they want to invade Grenada. They go to the OAS when they want preferential trade preferences. They go to the OAS when abuses of human rights violations in Latin America cause instability in the investment climate in Bolivia. That's the way the game works. I don't care. My clients don't care why Canada or the US or Guatemala follows these standards. All we care about is that they follow them. I don't care if it's in their calculated self-interest. I don't care if I have to go to Encana Energy Corporation to get them on my side. I don't care if I got to go to the European Union and hold up a decision from the IACHR denying and then tell them not to grant money to Nicaragua until they get this issue straight. All I care is that they recognize these standards and that gets them enforced. So if you look at the OAS, it's a regional organization. It's a regional human rights body. Article 2. This is, again, I'm going to run through this. How am I doing on time? Okay, that's all it'll take. So Article 2, all persons are equal before the law. That's the American Convention. There's a similar provision in the American Declaration. The American Convention is a treaty. States in the OAS have to sign on to it to be bound by it, but there's similar language in the Declaration. The Declaration, all the nation states of the OAS are basically bound to follow it, and it says, every person has a right to own such private property as meets the essential needs of decent living and helps to maintain the dignity of the individual and of the home. Post-World War II, individualistic discourse, nobody thought this would apply to Indians, right? Until Indians started going to the Inter-American Commission on Human Rights and the Inter-American Court of Human Rights. The first case brought by my program, and my colleague Jim Anaya is lead counsel on this. I was amicus counsel for National Congress of American Indians, involved an indigenous community in Nicaragua, Awastini, Mosquito Indians. And Nicaragua claimed control over the Atlantic coast and ownership over the Atlantic coast and the ability to license out the resources of the Atlantic coast under the doctrine of discovery. And this is what happens to indigenous peoples in 1990s under the doctrine of discovery. Okay, not very pretty. And so we brought a case before the commission because Nicaragua decided this was the traditional territory. It was all mapped with lots of sites, lots of place names in their own traditional language. This was what this community lived on. And this was what was left after the government granted its timber concession without any consultation or compensation. We lost in domestic courts. The domestic courts enforced the doctrine of discovery. So we went to the commission and we went to the New York Times and started to build up publicity. It's loggers versus Indians in Nicaragua. And it's always great when a government official says something like this. Nobody lives out there, the official in charge of National Forest, until somebody shows me a title, that land is government land. Thank you very much, Mr. Lanez. Reported in the New York Times. Work our case all the way up to the Inter-American Court. And here's what the court says. Nicaragua violated the right to property. Remember all that language there about private property? Well, what the commission and the court hold is, well, there's a right to equality in the American Convention and the American Declaration. And so since the basic fundamental norm of international law is equal treatment of people, it's not very equal to recognize the white fellow's property right, but not recognize the brown fellow's property right. And so therefore, we have to read Article 21 as applying not only to the property that white people own under government title, but to the property that indigenous peoples own under their own customary law. And once you've got that move, the world opens up. Nicaragua had the cease acts. We basically got that Korean company out of there. They hightailed it out. We're in the process of demarcation now for these traditional territories. Brooklyn Rivera, the leader of the Mosquitoes who had been fighting the Sandinistas, is now a member of Nicaragua's parliament and a member of Ortega's cabinet, and we're implementing the demarcation process. Several other cases in which we've built on this, and I'll just run through real quick and then open it up. The Dan case, some of you may have heard about Mary and Carrie Dan, Western Shoshone women, who went all the way through the Supreme Court and were told that they'd lost their Aboriginal lands over which they'd ranched their cattle by gradual encroachment of non-Indians. Never been a congressional act or a treaty taking away their lands, just the government never protected it. And so the government and the Supreme Court hold, well, you don't have any rights. Even though they've continued to range their cattle out on the public domain, and their ancestors have done so, no one's ever stopped them, the BLM comes in there and says, forget it. You're overgrazing the range, we're kicking you off. They go to the Supreme Court. The Supreme Court says, hey, you lost your land by gradual encroachment. So the Dans come to the Indigenous Peoples Law and Policy Program, Indian Law Resource Center, and combine a legal team and say, you know that case in Nicaragua, we think that might help us. And we go before the Inter-American Commission, and the Commission says that the United States violated the right to equality, the right to a fair trial, and the right to property of the Dans. Where property, and I'll leave it here, where property and user rights of Indigenous peoples arise from rights existing prior to the creation of a state, recognition by that state of the permanent and inalienable title of Indigenous peoples relative thereto, and to have such titles changed only by mutual consent between the state and the respective Indigenous peoples, when they have full knowledge and appreciation of the nature attributes of such property. This also implies the right to fair compensation. We now have two cases. We have a case in Belize, beautiful part of the country, involving the Maya, filed on behalf of 37 indigenous communities. Same situation, the government claimed the right to parcel out the land to large-scale timber companies. Based on these precedents, the commission held that the right to use and enjoy property may be impeded when the state or third parties affect the existence, value, use, or enjoyment of that property. Accordingly, and this is where we're at now, the organs of the American system have recognized that property rights protected by that system are not limited to those property interests that are already recognized by states or defined by domestic law, but rather that the right to property has an autonomous meaning in international human rights law. In this sense, the jurisprudence has acknowledged the property rights of indigenous peoples are not defined exclusively by entitlements within a state's formal legal regime, but also include that indigenous communal property that arises from and is grounded in indigenous custom and tradition. Two systems of property rights. After 500 years of denying indigenous peoples existence. In Australia, Australia was legally declared terra nullius, empty lands. It was as if the Aboriginal peoples never existed. Not only can the law protect indigenous peoples' property rights, but it gives them a reason to celebrate and to revive and to continue to practice their own traditional and customary laws over that land in a way which Western nation states must accommodate themselves to. So the answer is, does the law protect indigenous peoples' property rights? We have a case right now that I'm about to file against Canada involving Vancouver Island. The Cowichan Indians and Hulkaminam tribes go out to Salt Spring Island in the summer of 1887 to go fishing, and while they're gone, the British send their gunboats and bomb their villages on the mainland, and then basically imprison them when they come back and give their entire territory, 1/3 of the island of Vancouver, to a railroad corporation, which one of the primary stockholders is Leyland Stanford, of all people. Therefore, it continues to exist, shuts down the economy of British Columbia. And the government sets up what's called the British Columbia Treaty Commission to start negotiating, because 98% of the province of British Columbia has never had Aboriginal title extinguished. But the government does something funny. They say, we'll negotiate with you, but any lands granted to third parties are off the table. And for the Cowichan, that's everything, their entire land base. So he says, so what can we talk about? Nothing. So that's where we're at now. We have filed a petition against the government of Canada, the Inter-American Human Rights Commission, claiming that if the government does not want to recognize our native title to these lands, international law clearly obligates Canada to pay just compensation. And our economist, Joe Call from Harvard, has given us a nice figure of $3 to $4 billion. Now, finish up with my strategy here. Gee, right across from where the Cowichan's are is Whistler Mountain, the 2010 Olympics. Wouldn't that look great for the fuzzy, warm Canadians if you had an indigenous group claiming violation of human rights? Wouldn't Hugo Chavez love to hear that? Wouldn't we love to embarrass the government of Canada? We're in serious negotiations. Okay. So I'll take questions now. Thank you.
so some enlightenment has come in. It seemed to me that the citing of laws initially, as you started your lecture, was really just a question of ratiocination. In other words, it was a question of power, it was a question of imperial power, and one had to draw up reasons to extend that power, and that's what was happening all this time. And now it's only in recent times that a certain kind of enlightenment has come in, and the might makes right aspect of the whole issue has become partially resolved. Partially because, you have your international laws, but if you have a superpower, it doesn't have to recognize those laws if it sees it in its interest not to do so. So, I think it's very interesting to cite all the threads of law, but you also have to recognize what's really behind a lot of this.
And this type of practice, and this is what I try and convince students who are interested in international law. Too many Americans think, first of all, international law has no bite, it has nobody to enforce it. International law is going to The Hague, to the International Court of Justice, and we don't pay attention to that. That's not how the system works. As my clients continuously tell me, this case is just one of the tools we're using in our negotiations. It just puts a little bit more pressure, and it's all interest-based. And Canada isn't going to give us anything because they've signed the Convention for the Elimination of Racial Discrimination. They're going to give us something because it'll get in the way of the Olympics. Or their timber companies say, we can't get bank financing until you resolve this issue. And that's all my clients want. For the Dans, we fought for the Dans for 20 years. And you know what they did? They came to us and said, here's what we want. We want to keep grazing our cattle. Well, what else? That's all. We've come to you so we can keep, that's easy. No, it isn't, okay? And what we did, we managed to use this international system where you had the State Department calling the local BLM land range manager. Now, I can tell you the BLM can be pretty obtuse people. But when the State Department calls you and says, do not confiscate the Dans cattle in their herd, it has an effect. And it allowed us to buy some time in order to get that herd together and then auction it off in trust to somebody in California who's holding the herd. And the other thing that matters is, and this is why the Dans, God bless them, they realize that winning this case probably won't do much for them. But it contributes to a process of building a jurisprudence of indigenous rights in which it's preemptive. Don't go there. Don't do that. It's well established you can't do this anymore. And it's that prescriptive power that really is important and really holds the governments in check. Before all this I talked to you about in 1970, there was nothing there to stop. There was absolutely no law that could stop these countries from confiscating this property. There is now a tremendous range of arguments, a tremendous number of precedents that gives us the ammunition to slow these projects down. In Australia, we're involved in rather intensive consultations with the government and energy companies on land development. In Canada, up in Alberta, we're working with Encana and the Cold Lake First Nation on tar shale sands. Anytime oil goes over $60 a barrel, it makes sense to start developing tar shale, the oil sands up there. The problem is those oil sands are on lands that are aboriginally claimed by the Cold Lake Nation. And Encana, if you go to, it's the largest energy company in Canada, go to their website, and their second link is on all their human rights awards. And so the last thing they want is for us to open up a website saying Encana violates human rights. They're going to deal with us. And what's funny is that Alberta is freaking out. Alberta, the government, always wants to know when Cold Lake is meeting with Encana. They're afraid of their sovereignty and their power being bypassed. And so that's how this discourse, this dialogue changes the entire dynamics of what we're doing.
Well, first of all, thank you for a wonderful lecture, Rob. This was most enlightening. And I'm asking about what happens with cases like the Black Hills and the Lakota, where the U.S. Supreme Court acknowledged, that they have rights to the land, and they've been offered quote unquote just compensation, but that's millions of dollars. They want the land back.
Right.
Is that the next step? That they get what they want rather than monetary
Getting the Black Hills
compensation?
back, right. The Sioux want the Black Hills back, and they've, in 1980, I believe the United States Supreme Court, in a case called United States versus Sioux Nation, held that the Black Hills had been unlawfully taken, that the Black Hills had actually been a treaty. See, once you sign a treaty, then that means that your indigenous property right is protected by the Constitution. But that didn't matter because treaties were not governed by the Constitution. Congress could abrogate them, so Congress basically abrogated the Sioux Treaty, took the Black Hills, and found a taking in the amount of $100 million. And the Sioux refused they refused the money. They said the Black Hills are not for sale. So that money now sits in the U.S. Treasury. It's a couple $100 million, and they're never going to take it. The problem, of course, is, you've got to get the United States to agree to somehow make some sort of return or compensation. And within this framework, that's something I can't do. I mean, I can't imagine the United States Congress and Senate as it's comprised right now, simply saying, well, because it's a violation of international law, the Sioux ought to get the Black Hills back. But we have talked to members of the Black Hills Treaty Council, and we've actually talked with people like Mario Gonzalez and some of their counsel there on the idea of reframing this issue to at least build up some recognition. The problem is that Congress doesn't know this history. Congress doesn't know this story. My favorite story, you'll like this, about the Black Hills, how many people have seen Citizen Kane? What's the magic word in Citizen Kane? Rosebud. Okay? Where did Citizen Kane get his money from? Where did he buy the newspapers? The silver mine. Okay. The Hearst family got the patent to mine gold and silver out of the Black Hills. And there was a Sioux curse. And it's on the Rosebud Reservation. The Rosebud Sioux. There was a Sioux curse. Any white man who took anything of value out of the Black Hills would be cursed. And what's the story of Citizen Kane? He's cursed. And as he dies, what does he say? Rosebud. So, go watch the movie again. It's a totally different movie, knowing that. And Wells admitted that. Yeah. Rosebud. It's not a sleigh. Okay. All right.
This is similar to the remark about your characterization of the doctrine of discovery as really just makes right. I noticed that you told us that the papacy has jurisdiction, but there wasn't really a logic for why it had jurisdiction, at least that I heard.
Well, the logic was that actually Peter had granted jurisdiction over the universal Christian commonwealth to all the sheep in God's flock, actual or potential.
As I said, there wasn't really a logic to it.
Right.
But in any case,
but listen, in the Middle Ages, look, in the Middle Ages, okay, all these, first of all, the Crusades, for example, if you went on crusade, you got a plenary indulgence for the forgiveness of all sins. If you were killed, you died and went right to heaven. And given life in the Middle Ages, that wasn't a bad deal, right? So I mean, this is all about Hobbes and what has bite and where does sovereignty come from. But that was an effective system of jurisdiction up until the Reformation.
And I noticed as well that some of it was prefaced on there being Christian kings, but I'm sure that if they quote unquote converted indigenous peoples, that wouldn't have stopped kings. That wouldn't have stopped anything. In the same vein of it being makes right. I'm just wondering then. The turning points in international law that you pointed to included recognition of hunting and fishing, but not agriculture. I wonder if you could comment on that. That seems to reproduce the same logics of stereotypes that have no relation to what's actually going on.
Yeah. Well, let me talk to you about litigating cases in places like the Inter-American Commission, and if you can imagine who the commissioners are. Okay? Take your typical commissioner from Peru. He was probably the prima chair of constitutional law in Peru. He probably comes from a very high Ladino Hidalgo family. Okay? What do Indians do? They hunt and fish. What are they coming here asking us for protection for? The right to hunt and fish. What we're really asking for is title to the land so that we can engage in sustained yield management of the forest, mine it, hunt and fish. we don't necessarily tell them what we want to do with the land. And so, you know, and this is a good question. I get into this with my students all the time in stereotypes, okay? People have stereotypes. Judges and juries have stereotypes. And it's not a stereotype to think that my tribe up here in Prince George really wants to get at the timber to cut it as opposed to, CAM4. Okay. So what do? We build up a case of customary law. We show that our ownership is based on things like hunting, fishing, gathering. Quite frankly, these are not agricultural tribes. The Mayas had some agriculture, and we introduced that into evidence also. So where we have it, we introduce it. But good point. You just made me realize something. What's interesting is that most of the cases that we're dealing with or consult on are cases usually involving hunting and gathering tribes, and the mentality of the government is they have no property rights because they're so primitive. And so I imagine empirically, if you go around and you look at places where tribes have engaged in large plot agriculture, the government probably leaves them alone. Yeah. Well, South America. Yeah. That's an interesting point. I hadn't thought about that. But we use those stereotypes. You know, I remember my first case I did before the commission involved carrier seconding, and I asked my colleague Jim Anaya, I said, okay, I'm going to, who's done all this work all the time, I said, okay, Jim, so I'm going to do my first case, what should I do? He says, do you have a buffalo speech? I go, what do you mean? You have some chief who comes up there and talks about the buffalo roaming and the grass growing. They want to hear that stuff. Got to have a buffalo speech. So then the second, okay, I'll have my chief give a buffalo speech. Then the second thing is, you got somebody to say a prayer? What do you mean? Oh, yeah, these Latin Americans, they always think Indians are so spiritual and they're going to say prayers. So I had the carrier Sakeni, they're from Canada. They all went to the damn residential schools. They had the language beat out of them. So I go around to my 8 chiefs. I say, who can say a prayer? Well, we don't know anything. We had the language beat out. One old guy raised hand. The nuns taught me the Our Father in Sakani. I said, let me hear it. So I introduced my chief. Our chief is going to give thanks to the great Father for providing bread. Go ahead, chief. So you're talking to the wrong guy. I sleep well at nights, okay? I got to win cases. That's all I care about. But you've hit on an important issue, and you're dealing with it all the time. You deal with it in federal court. Anytime you're representing Indian people, you're going to confront this sort of, universe of stereotypes. And I don't have a lot of time to disabuse people of their stereotypes. I'm working within I have 60 pages on a brief or what have you, and it's really not enough time. I was on Nevada v. Hicks, a 2001 Supreme Court case. We lost 9-0. But it's the only case in the Supreme Court where the petitioner's brief has 3 paragraphs on the medieval popes and the doctrine of discovery. I got that in there. I wanted to write the whole brief on the doctrine of discovery and the medieval popes, but Native American Rights Fund, well, it's a jurisdiction case. Maybe we better talk about jurisdiction. So you don't get a lot of time. And my experience as a litigator is there's some stereotypes you got to confront head on and knock them out. And there's others that may work for you, and you strategize about them, and where they work for you, you go with it.
I have a multi-part question on international conventions. You were talking about the new UN, I can't remember the
Declaration
whole
on
title,
Indigenous Rights.
And I'm wondering what the likelihood is that will do something for American Indians, given that the U.S. is not very, does not look very favorably upon international legal obligations, and is probably not likely to sign on to it. And then going back to the Inter-American Court, I'm wondering if it's possible to ask for compensation for violations that were committed before that particular convention was signed, and then finally whether that is something that the U.S. can withdraw from, so that it's no longer subject to
okay.
that.
Without getting too technical, in international law, there are declarations and conventions. So you have the Universal Declaration of Human Rights. Every member of the United Nations signs on to the Universal Declaration. Human rights lawyers like to tell you it's aspirational, okay? It's like what we'd like to do, but we don't have to, okay? What we have to do is when we sign a covenant, like the covenant on the political and economic and social covenants. The U.S. didn't sign the covenants on human rights until the last decade. So the covenant is a treaty which actually subjects you can subject you to the Human Rights Committee, and there's reporting requirements, and it embarrasses you. So the declaration is purely aspirational. But what it does, it changes the rhetorical playing field. It totally reverses all the assumptions. So that if you're going into Congress and and I know this from the Dan case, okay? Once we got the decision from the Inter-American Commission, we're able to get the attention of certain interestingly named, well-known Eastern Massachusetts Democrats who invite us into their office because you can't get them to talk about losing a Supreme Court case. In fact, the fact that they lost the Supreme Court is dispositive. I can't do anything about it. But when you tell them that the Inter-American Commission has found that despite the Supreme Court decision, it's a fundamental violation of human rights, it opens up the dialogue again and creates space for negotiation. As for the second issue, the issue of just compensation, you'll notice that in my lecture, all of the discussion has to do with historical takings. That's, to me, the really exciting part about where this jurisprudence is at. And this is what I try and make clear to my students. The international system doesn't give a damn about history. It really could care less. The Kurds got screwed, the Bantus got screwed, the Sioux got screwed. I mean, if we cared about history, we'd never get anything done. Here's what we care about: your cultural survival right now. How does that history affect your cultural survival? And if you read all those cases, there's a clear recognition that the history of dispossession is what's placed indigenous peoples in such a precarious situation relative to their cultural survival. And if we're going to save these people, then we have to do something right now. What do? Give us back our property that was taken back in history. I get it. Okay. And that's the game that you're playing. That's the discursive game. It's a much different game. And my students are disappointed because they think, oh, we're going to do human rights. We're going to save the world. You know, we're going to be normative all the time. I say, I don't want no normativity here, okay? No normativity. This is all pragmatic. What can get done? How do you structure arguments so that your clients can win? How do you create negotiating space? I doubt if in my entire lifetime on any of these cases I'm working, and Jim and I talk about this all the time, when do we get out? This is like Tony Soprano, okay? You know, he's been going down to Nicaragua for 20 years. I don't know if he's ever flown Nicaragua's, airlines, but it's amazing he's still alive, okay? It's not a very safe thing to do. You never get out. This is all part of the process. This is not focused on domestic litigation. And I think that's why Fred's question to me, can the law protect indigenous Americans? I'm very skeptical on the ability of the conqueror's courts. Remember Johnson v. McIntosh? Justice Marshall said it right there. He said, conquest gives a title which the courts of the conqueror cannot deny. Conquest gives a title which the courts of the conqueror cannot deny. Don't come to us, okay? You guys lost. Don't come to us. I mean, any Indian lawyer who sees that has to sit back and say, it's Audre Lorde. The master's house was not built to be dismantled by the master's tools. And all these federal Indian lawyers who are spending a lot of time litigating these cases, Indian law, federal Indian law sets a ceiling. You're never going to get greater rights than the dominant society. You're never going to get your property back. That's like John Wayne said, we didn't take that land from those Indians. We fought them for it fair and square. You're not going to get it back. Okay? They don't want to give it back, but maybe you can find negotiating space to give you some leverage to get some of it back. And that's the situation that you're dealing with. It's a much different mentality from sort of the win-lose. If there's lawyers here, we know about Hofeldian jurisprudence says, if I recognize a right in you, then I've lost and I have a duty. So rights are a zero-sum game. My recognizing a right for you means I lose something. Okay, that's the mentality of the Western legal system. You win, I lose. And that's not what we're trying to do here. What we're trying to do is something much different. We're trying to enforce normative standards of conduct that have never been recognized before and insert them into the dialogue, into the negotiations as having substantive force, as something that has to be paid attention to, and then working around the margins. Okay, thank you.